A private legal practitioner, Nana Ejay Bafwewa, has urged the Electoral Commission to reconsider its decision, its disqualification of the 12 presidential aspirants. He argued, though they had some powers, it was discretionary, saying in pursuance of the Article 296, the Constitution imposes on anyone who exercises such discretionary powers to be fair and candid.
The EC last Monday disqualified 12 presidential aspirants, including that of the PPP, NDP, PNC and GCPP, from contesting this year's general election. Among the issues that formed the basis for the disqualification were failure by some of the aspirants to fully complete the nomination forms and use of double registrant in the completion of the forms. But private legal practitioner Nana Ejay Bafwewa is of the view the CI 94 law mandating the EC to organize elections from the filing of nominations of candidates to the declaration of results is deficient.
The Commission has published a regulation that is supposed to guide them in the performance of their work. That regulation ought to have set out that guideline, spelling out the basis upon which such decision would be made. But that regulation did not spell it out. This CI 94 in itself appears to be deficient.
He noted the EC chair was exercising a discretionary power, and according to Article 296 of the 1992 Constitution, anyone exercising such discretionary power must not act arbitrarily but apply the rules of natural justice.
What does the law say when you are exercising a discretionary power? The rules of natural justice would have to be complied with, because you are making a decision in respect of a person, and therefore you ought to give that person a hearing. Did they give them a hearing? There's a problem there.
He said the current state of affairs could have been avoided if the EC had given ample time to the political parties and the aspirants to file. Lawyer Bafwewa insists the EC chair is obliged under Regulation 9, subsection 2 and 3 of CI 94 to inform the aspirant about the mistakes and give them a chance to amend them.
This particular provision places on the Electoral Commission chairperson as the returning officer two obligations. The first obligation is to inform them within the nomination period. So after you have informed them, then you have an obligation to also give them the opportunity to make amendments or any alteration necessary